Good morning. So we're joined here today with June Hu from Sullivan and Cromwell, and we're really happy to have her to talk about her experiences advising companies on ESG disclosure laws and a lot of other related legal areas. So thanks so much, June, for coming and joining us today.
Thanks very much for having me, Patrick.
So first, I'd like to just learn a little bit about your journey towards ESG law and how you found your this practice shaping up over the last few years.
Sure. When I was a law student over a decade ago at this point.
I know, doesn't it seem odd saying over a decade? I've been saying that too.
Yeah, I teach a class at Columbia, and the first time I taught it was the 10th anniversary of when I was a student in that class. And I remember telling that fact to my students and being greeted with this devastating, wow, like you're very type of a response. But alas, when I was there, eons ago, there really wasn't anything that we would now call, ESG law. It wasn't taught in school. So I'm always really impressed and fascinated when I hear students who come to me and say they understand ESG, they're interested in ESG, and they want to practice in that area. When I started practicing at Sullivan and Cromwell, which takes a very generalist approach, I worked in a little bit of everything related to corporate. I worked in M&A work. I did a lot of transaction work. I did capital markets work. I did disclosure work, some regulatory work, and I worked a lot with corporate governance, right? Back then, things like special meeting, written consent, all of those things that were in focus at the time. And, over the years of my practice, you really saw, especially in the corporate governance field, this increasing focus initially in the US on social issues, right? With Me Too, Black Lives Matter, a lot of focus on diversity, representation, workforce issues. And then, I would say more recently, an increasing focus in corporate America on issues that relate to the environment, particularly climate change. And so, as that area of my practice evolved and grew, and my interest in that area continued to increase, at some point it made sense for my career and for the firm to have me coordinate the practice, the ESG practice at Sullivan and Cromwell.
So that's fantastic. So you're working on the ESG practice as a whole, and obviously Sullivan Cromwell is a prestigious and large organization. So I would imagine that offers a lot of opportunity to collaborate within the firm.
Yeah, exactly. When I say coordinate, I really mean it. There is not one person who owns or leads the ESG practice at Sullivan and Cromwell. Just to give you an example, when we have our monthly meetings, right, to talk about ESG issue, we have tax lawyers, we have, trust and estates lawyers, we have, transactional folks, we have people from, our European offices, people focused in the global South, we have, litigators, investigations folks, and obviously our regulatory lawyers and financial institutions lawyers, all represented on these discussions. And they tend to be really robust and cross-functional. And, not only in these group meetings, but in the way that we represent clients too, right? We try to consult with each other, and we like to consult with each other on these issues and frameworks that are just emerging, but that, have a bunch of, potential red flags that range from litigation all the way to tax, right? So I think when we say we practice ESG, what we really try to do is to take a 360-degree view to issues that are not simple, that are complex, and that are evolving really quickly, where if you're only looking at one piece of the issue, you may be missing something big.
And it's really important to have that holistic sense, for instance, because you need to be thinking about how the disclosures you're making might have implications broadly over the course of a few years. So for company in the human rights context, if you disclose problems related to your supply chain. That's obviously good and important and shows that you're doing proper due diligence, but it also allows for a potential liability in the future. So there's the downside risk from your complying with one regulatory requirement. So in one regulatory arena, you're satisfying the requirements, but then that makes you be not necessarily compliant with another area. And then another thing I wanted to ask you about, what an interesting area when we talk about ESG law is it's oftentimes new. And although we laughed about being in law school a decade ago, that's better than a lot of these partners who were in law school, back in the 80s when they were using typewriters and things like that. So how have you found the practice of ESG law where a lot of it is novel, interesting, new legal areas?
Yeah, I think it's really, really exciting. I know there are days where it feels daunting, right? Because you don't really have a set playbook that you follow. You're not, copy and pasting in a precedent, and you really have to think about issues that are a mixture of legal policy and really what's happening on a day-to-day basis in the news cycle, even these days. But I think that's also really exciting. One thing I tell to young lawyers who are interested in working with me in the ESG practice at Sullivan and Cromwell is you get to be the world's expert on these new issues as they come out, right?
Mm.
The initial threshold to entry is actually in a lot of ways lower. If you're willing to be the person who reads the fastest, the closest, who thinks really hard about these issues, you will be the world's expert on it. And I remember, just to tie into California, since we're here on this forum, I remember when the California laws came out back in October of last year, some of the leaders at our firm in this area were, our first year, second year, young lawyers who were, looking through the legislative history, doing the research into the California parliamentary process, right? Looking at all of these details that were really, really helpful to inform the way that we as a firm structured our thought leadership and advise clients on novel and evolving requirements. So I would encourage, folks who are considering coming into the ESG practice to be excited about the possibilities represented in this new area. But I think one of the things to make sure you do at this moment in time is, if you're somewhere in the middle or quite advanced in your practice, this is a moment to put down your pride a little bit, right? Because we really do need to work away from silos. And some organizations are really good at that. It's part of their culture. Maybe some others will need to retool, how they're thinking about it. But I do really
there's some law firms and partners who can be quite territorial and quite staid in
yeah.
I
But this
assume Sullivan and Cromwell is not like that.
Yeah, that's right. We like to think of ourselves, and we pride ourselves on consulting regularly, almost incessantly. But the benefit of that is your client will get a more well-rounded set of views, right, on issues that are just not one-dimensional. I'll give an example of that, right? When we are talking about, the SEC's new climate rules. My first call was to a litigator, right, about what actually is the liability expansion here, right? How did the safe harbor work? My second call was to my colleagues in the European and California offices about the overlap between, the European sustainability reporting directive versus the California one, and how the various standards of materiality, right, will impact each other in practice. So I really do think this is the moment in time where, your practice, your ability to be a lawyer who serves your client well is going to be, at least partially based.
Contingent upon your ability to collaborate with others, right?
Yeah.
Because it's not, one thing you mentioned earlier that I was thinking was that part of the reason why you can have an advantage in this space as kind of a new mover is if you're interested in climate change and learning about greenhouse gas emissions and learning about how supply chain scope 3 emissions affect overall climate change risk and materiality, then you'll have a leg up because you'll have a legal background as well as kind of a practical understanding of the issues at play. And then if you can add to that a collaborative kind of network capability to speak with many different lawyers who have several different disciplines, that just magnifies your ability to give really great advice and really effective advice too. Because I think and I would hope most of the lawyers that are interested in getting into the space are doing it in part because they want to make sure that their legal work corresponds with their own kind of ideals with respect to social impact, right? I mean, would you find that as well?
I agree. When especially our younger colleagues come to us and they say, I want to do ESG, it's really because they want to make sure an area that they're passionate about is reflected into their day-to-day work. And I think that's right. And, but that's the great part of this, right? Which is that right now within your law firm and if you're in-house within your broader organization, there'll be other people who are interested in talking about this, either because it is also their passion or because it has some kind of immediate or longer term impact on the way that they perform their work as well. And I would say, right, when you're thinking about building networks, building connections in this space, I wouldn't just stop at, other lawyers. What I've found to be really, really helpful is that, Sullivan and Cromwell collaborates regularly with people who are service providers on ESG and other spaces. We talk to people who provide greenhouse gas attestation, who do the accounting work, right, who are in academia writing articles both against and in favor of ESG policymakers. I remember back in 2022, right, the entire summer of 2022, spending that entire time helping clients and writing on our own behalf comment letters to the SEC about, things to do to improve its rulemaking. I think actually Sullivan and Cromwell's comment letter was cited 50 something times the most number of times by any other law firm compared to any other law firm in the SEC's adopting release, which felt good.
That's
but
great. That's cool.
But also we represented clients, trade organizations, investors, and others who were cited very frequently by the final release when the SEC adopted the rules as well. So I think, from a personal perspective, right, talking about a trajectory of a lawyer in ESG, that experience, the idea of talking to people who have their boots on the ground in this area, which often is not the case for lawyers, especially for external counsel. It was an invaluable experience because you really do realize the subject matter expertise that is required to, execute on some of these new regulations that are coming into place to meet, the investor expectations, which are increasing and diversifying actually in this area.
No, I often find that a lot of our work and a lot of value add that we can provide as, ESG lawyers is our ability to liaise and have connections and networks with service providers, because a lot of the quote unquote work is done by them. They're the ones accumulating and compiling all the data and information, and we're just giving advice on what exactly information you need to do and how do you package that information, things like that. But the people who are acquiring and compiling all of that are separate. So having good relationships with that is important. And
Yes.
one thing, just to get back to this idea, I think it kind of mirrors the generational evolution. So if you think about kind of the 2000s and the Generation X lawyers who came up with CSR, which is we have a business model and on the side, we're going to do something that's responsible. And you can kind of consider that consistent with the idea of a law firm that has a substantial pro bono practice, right? Because they find it's important to do that. Whereas you have kind of the millennial generation where we say we want to incorporate, you know, socially responsible practices within our work. And I think a lot of ESG is differentiates itself from CSR because it means incorporating these different practices within your business practices, within your business model, rather than simply just having something on the side. I think I was talking to somebody the other day about a company that has, you know, a giveaway. That might be something that's good, but if you're, you know, a company that's main role is polluting and you do a little bit of giveaway, that still doesn't really balance out. So another thing I wanted to talk about is, given that you're based in New York, I'm assuming that you spend a lot of time working on the new SEC disclosure rules. So I'd really love to get into that, how you've been advising companies on responding to those. I understand implementation is not until 2025, but people need to get their ducks in a row now. And I'd also really love to talk to you about the litigation backlash that has arisen after, in response to the disclosure laws. So perhaps first you could give us a very quick overview of what's your 5-minute brief summary of the disclosure laws that the SEC has passed, and then we can talk a bit more.
Sure. I mean, look, I've been talking about the SEC disclosure laws a lot and a lot about the litigation recently, but I really think the key takeaway for companies, right, especially ones that have started doing the voluntary reporting along the TCFD framework or similar well-established frameworks, the work is not going to be, putting the information together, but it's going to be the controls that are in place to vet the information you collect, or uplifts that you'll have to make a disclosure that now will need to be included in your SEC filings. Let me just backtrack a little bit, because the SEC prior to these new climate rules had in place this materiality-based guidance, right? So if information was financially material under the Supreme Court standard, and it related to climate, then you had to disclose it, right? That's pretty straightforward. That's the typical, SEC disclosure framework. And what this new requirement does, even though it still refers to the Supreme Court definition of materiality throughout, is that it goes into a lot of detail about what types of climate-related information a company may have to disclose if it is material. So for example, climate-related risks, and those are broken down into physical risks and transition risks, right? Transition risks being the risks related to regulation, business trends, as a result or in response to climate change.
Let me just ask, does it effectively mean that there's now a presumption that these issues are material? Does it move that needle forward, such that if a company wants to say, we're not disclosing this because we don't think this climate risk is material, there's almost a presumption that they would have to overcome?
I think presumption is probably too strong of a word, right? I think, the SEC, as they talk about in their adopting release, there are scenarios where a company can take a determination after analysis, quantitative and quantitative, and determine that nothing needs to be disclosed because it's not material based on the company's specific circumstances. But I do think, Patrick, what you're identifying is almost a stronger argument that somebody could make or would be more likely to make, whether that's the SEC staff in comment letters questioning you or a private litigant, right? Saying, hey, I think that information that you talk about elsewhere in your voluntary reporting or your disclosure under California, which is not qualified by materiality, that disclosure needs to be included in the SEC filings, and because it wasn't, there's somehow a material omission, right? And think about it. So this disclosure needs to be in your 10K annual report, meaning that it's automatically incorporated by reference into your registration statements. So subject to that higher, stricter level of review that offerings of securities and documents where you you register your securities are subject to. So I think for companies that collect this type of information, what will really, really be the important thing to do, and this is where lawyers come in, right, is to work across a group of, the internal stakeholders, work with external advisors to really figure out what uplifts are needed to take the information you probably collect and talk about today, and subject it to the same controls you have in place, right, for your other SEC reporting, meaning, how do you get it comfortable so that your CEO, CFO can sign off on it in their SOX certificate? How do you, there's an aspect of the new SEC rules where you have to disclose in footnotes to the financial statements, right, material financial impacts of certain types of activities you do to mitigate climate or adapt to climate change. You'll have to, subject to a very low threshold, talk about the financial impact of, severe weather events and other natural conditions, right? Whatever that means. So you'll have to talk to your auditors, your internal, external audit to get aligned on that too. So it's really a process of making what you disclose subject
Much more
to
bulletproof. It's kind of like you're stress testing the information that's being disclosed. You as a lawyer are making sure that it's accurate and it can stand up to a bit of scrutiny in the context of
sorry, I just want to push back on that, because I think it's not the lawyer's job to necessarily make sure that the information is true. The lawyer is there to create a process where somebody, right? It could be the climate, professional. It could be, even in some cases, it's a third party that gives you data. Just making sure that there's a process in place to stress test that data.
Yeah, no, I agree. What I was because of course we're not going to be the ones on the ground making sure that everything being measured is accurate. What I was thinking about in the context of greenwashing litigation risk, when you're doing a kind of greenwashing litigation risk assessment, you almost have to look at the company's statements and then say, well, how do you support that? How do you validate that? That it's a process of stress testing it to make sure that it can stand up in, say, court if somebody asks, what do you have to validate this information, or was it just puffery?
I mean, I think when you talk about greenwashing, right, I think that's really important, because a lot of the greenwashing lawsuits that have moved forward have been kind of in the consumer protection advertising space, which is a little bit different, right? Like anything that you say about, publicly to sell a product, to differentiate yourself about climate, goes into that bucket. And there are new laws and regulations depending on the state you're in, the federal regime in place that overlay onto that. But I do think it's worth noting, right, that in the SEC disclosure context, the important thing is that, for a long time, people had made the claim that climate-related information, even if it's wrong, right, in a SEC disclosure, was not material. And I think, what we were talking about just now, it's not necessarily a presumption that something is material, but there may be better arguments that something is, because, a court may defer to the SEC's, interpretation or examples, of which it includes many in the 900-page adopting release, to say, okay, something could be material.
And I wonder if that brings us to the litigation backlash following the SEC rules. Maybe you can tell me a bit about that and how that's progressed.
I think the existence of the litigation is probably the least surprising thing about the rules.
Oh, yeah.
Yeah. So, day one, we had a group of red state attorneys generals who filed a lawsuit. And actually, in fact, at the end of the day, 3 different groups of red state attorney generals filed petitions: energy companies, the U.S. Chamber of Commerce, but also pro-climate groups, right, who thought the SEC didn't go enough. And I think here it's really, really interesting. And brings me back again to decades ago, my law school days, where con law was very much top of mind. But I mean, it's really interesting to think about the issues at play. The main arguments are, on the side of, the SEC shouldn't have done this, right? They didn't have authority. This went too far. There's a First Amendment argument saying that this is, impermissible compelled speech. And in fact, the same argument comes up, in the California lawsuits, right? The Chambers lawsuit about the constitutionality of the California laws requiring climate-related disclosure. And then the second one, right, is the kind of, does the SEC as a agency have authority? Do they have clearly delegated authority? Kind of the major questions, doctrine, that arm of arguments. And then the third is the Administrative Procedure Act elements, right? Did the SEC take the right processes here before it adopted? And one of the questions is, given the large amount of changes between the proposed rules and the final rule, should the SEC have re-proposed? Should there have been another opportunity for market participants to react before this came in? And I think
don't the subsequently passed laws, aren't they a lot less burdensome on companies?
I mean, but that's not the crux of administrative procedure, right? The procedure is about the procedure and not the substance of the law itself. The first two arguments, you're right, the first two arguments are much more focused on what do the laws contain. And I think even when you talk to the people who are saying the SEC overstepped, they would tell you, had the SEC adopted the original version, it would have been much stronger arguments. So, but the way the court decides here, right, will really have implications, and to law nerds like myself, it's probably really interesting, because if the SEC goes on the narrowest ground of the procedure, the SEC itself can try again. Like, it can try again, it can repropose, it can come out with rules that are similar to what it's proposed, right? If it's a, however,
if it's compelled speech, for instance.
Exactly. But I think if it's a major questions issue, if it's the SEC authority issue, you could actually see, another agency maybe being able to do it if it has a clearer remit. Another agency maybe being better suited to do this type of stuff. And then what that kind of an argument would do is it would also leave the states free to go out and continue what we've seen, right? Which is, as soon as California came out with its legislation, we saw very similar laws being proposed in New York, Illinois, and other states. But if it's a First Amendment argument, I agree with you, Patrick. But I think it'd be difficult to say that, the First Amendment, which has been, adopted by states, it is not going to apply here, right? So the fact that we may be able to see a decision from a district court as early as maybe later this year, end of this year, on the SEC's rules, and not just on like procedural issues, but on the merits of that rule, could really have impact for what we see in terms of ESG regulation in the future in the United States.
So I'm not a specialist in this area, and I haven't read the filings, but my understanding is that the SEC requires companies to make a number of different pronouncements and disclosures. So I'm curious to see how they're teasing between some types of disclosures and other type of disclosures. And then I think the more interesting point, and I think you spoke to it, this kind of second argument is this really the SEC's role? Is this really a regulation designed to protect investors? Is there really a problem where investors need to be protected by inaccurate disclosures? Or is this an environmental law put in through the SEC regulations? So I think that's probably the most interesting question, maybe substantively. I'm sure there are legal niceties that can be made too, but if we really want to get down to the heart of it, is whether or not there is a risk that investors might be swayed or damaged because of inaccurate disclosures. I wonder if you have any kind of thoughts on that.
Now you're sounding like the folks who were on the congressional hearing yesterday about the SEC rules. But I will say, right, the SEC's argument is that it's tying these disclosure requirements to financial and Supreme Court materiality. And so what we've seen in the investment community too, right, if you blackline year over year the changes in the major institutional investors policy, you see this shift away from environmental, social governance for their own sake, to this increasing attention on material risk, material opportunity, and a company's ability, especially management's ability, to oversee those material areas. And so I think if you are a company who's thinking, oh my God, there's a lot of political risk on this, people are moving back and forth, investors are dropping out of these, climate focused alliances, which I do at this moment. I think if you have some resource and you want to dedicate your resources in this area, one thing that makes sense to do is to really have a cross collaborational, framework for thinking through what is a material issue to you, right? What is a material climate related risk or opportunity in your company, in your industry, in your geographical location, et cetera. So I really think if that's where you're focused at this moment in time, you have a better narrative vis-a-vis stakeholders who are really in the United States very divergent in what they're looking for.
And you've been really generous with your time. I really appreciate you coming on today. Kind of final question I'd like to ask is, where do you see the next 5 years of maybe in this space, in the disclosure space, or maybe even more broadly in the context of different areas of environmental social governance?
I think there's a lot of focus these days on the E, environmental, social, and governance, which is a little bit of a change, right? Because, a couple of years ago, I think most of us in this space were focusing more on the S side. I do think with all the union activity and the post-Harvard litigation regulatory developments, we may see the reemergence of S over the next couple of years. So kind of a medium term refocusing of the social issues, both diversity and workforce labor issues, human capital management. The SEC is scheduled to have some rulemaking on this area soon as well. I would say kind of in a longer term trajectory, right? Especially where climate is concerned. I would expect to see two different movements, and I think they'll have different reactions from different stakeholders. And one is this kind of more reactive move towards the various regulations and standards that are emerging, where lawyers can be very, very helpful, right, in kind of designing frameworks to manage for the uncertainty, but making sure that a company is at all times aligned with regulatory requirements. And then another area where I think the lawyer's role is much more advisory, much more in the role of kind of someone taking a backseat, supporting the client.
The counsel role, right?
Counsel role. And I think that's much more in the transition space, because if you look at the numbers on climate change, the latest data, the latest science, right? I think talking about it is not going to be enough. And there are so many opportunities and there are beginning to be many incentives to do the type of deals, to investing the type of transformative technologies that may actually facilitate and accelerate what we're doing in this space. And so I think, if you're just looking at, how do I meet disclosure laws and how do I allocate resources to only comply and react, you may be missing out on real opportunities. Your client may be missing out on real opportunities, and you as a lawyer may be missing out on real professional opportunities as well.
And and I'm sure you've probably had a lot of conversations with your European counterparts. That's what I'm hearing from a lot of my European counterparts who are much more advanced stage given the nature of their regulatory evolution. And they say a lot of their job is change management and change evolution and facilitating change management at these companies. And the companies there are finding that once they implement these new protocols and procedures, how much money they can save, how much better running, they are finding a lot of benefits to doing it. And it's just interesting that lawyers are, not necessarily the first ones you think about being change makers. You think of us normally as being the conservative, the crossing guards for these companies.
No, I think that's such a great word for it. I think in the US especially, there is almost a sense of the ESG lawyer as, the crisis response manager, way, especially given the fragmentation on ESG in the last 2-3 years, right, in the United States. And I think that's probably not enough. I think if we were able to be both the crisis managers and the change, what was the word that you used? That was like
I think it's a change managers, so
the
we can't.
change managers. Yeah, I love
Change
that.
facilitators,
Yeah,
right?
the change facilitators. I think if we're able to play both roles, that will create a career path, right? That is sustainable in this space, and that really, I think, helps you align with the ultimate, interest that may have brought you into this space, which is a future that looks better than, where it may have been without this change management and this crisis management.
Well, I think that's a great place to end. Once again, I really appreciate you coming on today. It's really fortunate to have our colleagues in New York to cross collaborate and partner on these issues. So great to have you.
Lovely to chat.